Greetings. Welcome to TLJT Talks. This podcast discusses the interrelation between law and technology. Now, today we are very lucky to have with us Ms. Sharwari Pandit, an NLSIU graduate and an MBA candidate and a Forte Fellow, a Foundation Fellow at the Cornell Johnson Graduate School of Management. She's also certified at GDPR compliance by National Association of State Board of Accountancy. Today, we will be discussing and speaking about privacy laws in India versus abroad. My very first question to you, ma'am, would be, how would you define privacy? And how has privacy as a right in law, evolved over centuries?
Yeah, no, it's actually quite interesting. I think the definition of privacy itself has evolved over centuries. So if you look at it in law, you start seeing the mentions of it really, more than 100 years ago, when you have Justices Warren and Brandeis who write a really famous article in the Harvard Law Review, introducing a right of privacy, so to say, not really as an independent right, but more as a form of interpretation, of what constitutes personal space, and in a situation that's not really different now. One of the reasons where privacy gets picked up in this article especially is more from the point of view of protecting information of what happens within your four walls of your house, and not having the then paparazzi report it in the newspapers. And that's kind of where it really starts from. And after that, the right didn't really become an independent right until a few decades ago, but it kept being increased in scope, through the existing. It could be rights to, your own information, to the four walls of your house, and to any kind of public perception of you. And then, of course, over the last 20 to 30 years, we've seen this kind of explosion, so to speak, of privacy law, and really a way of carving it out as a separate right that's really independent of its own, and it comes hand to hand with the digital kind of explosion that we've seen, because all of a sudden, data is not simply controlled by intermediaries such as the few major newspapers, etc., but really it's accessible to everyone. And information that you've started putting out there on the internet, it can be accessed by the platforms, but also by an entire industry behind them. And so that's when really the law as well kind of concurrently starts growing and expanding. And now, of course, we have a standalone right in India. We've kind of it's been classified as one of our fundamental rights, so to say, through the Puttaswamy judgment in 2017, and things have kind of moved fast after that. And then that's kind of really how it's evolved. Of course, in the EU, they've kind of been, I would say, further ahead than most of the world on it. And so you do have a very, very comprehensive legislation, probably the strongest in the world right now, and really kind of an evolution, not just of privacy as a right, but then also what are the associate rights, of data subjects under it, duties of data fiduciaries, and kind of really setting up a structure around this area of law. In the US, you have a slightly different system where it's a little more fragmented. So you have certain states which have extremely strong laws relatively, and then you have certain states where that's not really the case. And India, I think, is an interesting precipice, because if you look at the large amount of data that we're going to be creating, using as an economy that's growing, working with, it's very interesting and important for us to really define how we're going to look at privacy in India for the next 10, 20 years, which is what the upcoming, act and legislation is going to do for us.
Yes, ma'am. Ma'am, how does India's data protection bill stack up against what is considered, as you have said yourself, the world's most comprehensive data protection framework? There is the EU General Data Protection Regulation. How does India stack up against it?
So I think as of now, before the act really kind of comes in play, naturally we don't really have a dedicated legislation to privacy, and so we have regulations under the IT Act, some of them which are, applicable, a patchwork of clauses in different acts, which have started to acknowledge privacy, so to say, implicitly. But really, this will be our first comprehensive legislation. I would say, to start off, it is fairly comprehensive. I think it would stack off fairly well against the GDPR. But I think beyond that, that comparison also starts, absolute comparison also probably doesn't make sense, because the places where these where these kind of geographies are in terms of where they're moving legally are a little different. So if you look at GDPR, that's a legislation that's been kind of in action for quite a few years. It has also seen its own overhauls, and it has then designed itself around the consolidated EU market, so to speak, and it has then leveraged the strength of that market. And you could see that in the way the privacy shield and the safe harbor negotiations went down, and how that issue evolved. In India right now, we're at a more nascent stage. And I would say, to that extent, having a comprehensive legislation itself is an extremely welcome development for us. And of course, we can go into the nuances of it, but I think that really on the basics of establishing, a certain set of rights for our data subjects, of really identifying data fiduciaries, giving them a set of duties, and really kind of carving out the roles of these different players, I think the Act is a big step forward for us.
Yes, ma'am, that is true. Now, how different would our situation on, the WhatsApp controversy have been if we had a data protection law such as GDPR?
So naturally it would have been different. In India right now, we are looking at the question of what should a platform or an intermediary's liability be, and right now it's largely governed by judicial precedent, and once you have a law that comes in place, these things become clearer. And you will actually see, it's interesting to note that even between the act that had come out, the bill that had come out, in 2019, and then the committee's reports that came out more recently, we've seen certain developments and changes there. And it could be anyone's guess, but of course, we have seen some of the use cases of such provisions play out in real life. WhatsApp controversy could be one of them. And so, yeah, I think definitely the state would have had a much firmer grounding to kind of start a dialogue with an intermediary or a platform in such a situation. I think, however, it also ties back to the larger question of balancing the two, because as much as, intermediary liability is a hotly contested issue, and naturally there's a call, not just legally, but I think also ethically now, for some of the larger platforms to really take ownership of some of the content that gets shared on their platforms. It does come that there needs to be a balance also from a freedom of expression and speech point of view, because again, these platforms are highly democratic in a sense, and they do really give access to a lot of people that they to kind of share their stories and viewpoints that they might not be able to do otherwise. And so policing that again becomes slightly dangerous, from in a democracy. And so really finding that balance is important. And of course, the act now talks about, the proposed act, it talks about it. It gives the state certain inherent powers. There's a new non-obstante clause which comes in, which in itself is remarkable. But I think really what we're going to have to watch out for in this case is that the next time there's a conflict that arises like this, and if the act it has been enforced, how are the different parties going to really leverage their own rights within the act? And that really needs to be seen.
Yes, ma'am, that is true. Ma'am, what can India learn from US Equifax and other data breach cases which result in cybercrime?
So, this is more of an instance of, I don't think there's much for us to learn per se, but I think to really start proactively taking the steps to ensure that, fewer people are victims of cyber crimes. And I don't mean that necessarily just as, as individuals, but I mean that as consumers of services that are provided by larger companies, and the kind of vulnerability that comes from having shared your data, especially sensitive personal data with service providers. Now, let me just break that down, because that was a little vague, right? So what that basically means is that right now, let's take any major bank. It could be SBI, it could be ICICI, it could be really any other major bank in the country. And I'm sharing a fair amount of personal data, which is then being stored on certain servers, etc. Now, most companies, of course, to give them credit, have a set of security, internal policies, and kind of standards that they use to make sure that such data is kept secure. That said, any lapse in them, or sometimes just malicious intent from an external party can lead to a hack, or it can lead to a data breach. And once that happens, I think the kind of exposure that and the kind of potential offenses that can be committed against persons who have shared their data, that starts becoming really scary. And it's not as if these are scandals. So the Equifax is one, but it isn't as though you haven't seen such breaches happen in other parts of the world, and even in India. So I mean, we could go through several examples, where in fact there were just lapses in security, which led to a certain data breaches. I think it's a great thing that the act actively addresses that. So especially in the most recent version, where you're starting to see certain very specific guidelines come through. So for example, companies or entities will have to report data breaches within 72 hours, is a great start. And I think it's really going to rest on the regulations and the nuances of guidelines that are going to come from the authorities for companies, or for data fiduciaries, because really that aspect of it, the protocols that are set in, as well as the enforcement, those are really the two drivers of a framework that makes sure that the right action is taken against data breaches. Because beyond the point, even after all the security measures are taken, or there is complete compliances with whatever regulations have been put out by the authority, sometimes an entity can be a victim of a data breach. And then what is important is really having the right mechanisms in place. So to give you an example, if you take a large multinational, do they really have a protocol, an emergency protocol for what happens in the first 24 hours after a data breach? Do they really have notification mechanisms for all of their, for anyone who might be impacted by such data breach? And a good set of regulations will cover that. And so we really have to wait and watch as to what comes out from the authority once it starts working.
Yes, ma'am, that is true. Ma'am, how would the new, privacy laws in India and China affect multinational businesses that basically outsource industry functions, or, maintain their operations in those, in these nations? So how would they be affected with this move?
Well, that's a good question. And I mean, there is significant impact that's going to come in on a range of companies, multinationals for sure, but even smaller businesses, etc. Once these regulations come in, and if you kind of zoom out, in a sense, it's no different from any new set of regulations come in, because what they do is that they bring in a set of responsibilities and compliances that the entity has to start ensuring that they adhere to. And so you could be a large multinational company in India, and you will have to start, I mean, and the impact of these legislations is going to be extremely wide ranging. So to give you an example, if you are an employer of a large number of people, suddenly, you're going to have to start taking a large amount of consent. The way in which you treat that data is going to have to change completely. So, earlier, for example, there there weren't really guidelines on, say, retention, on how to process this data, on who it can be shared with. And now if I'm if I'm an organization and I'm collecting that kind of data from various sources, I'm going to have to design my processes so that I'm compliant. And so that is going to need some amount of legwork. My understanding is that the companies will be given around 24 months in order to fully start being held to fully kind of work their systems around to make sure that they're compliant. And that's very reasonable, because the large amount of shifts that's going to happen at the back end of how those companies are running and using their data is going to be enormous. I mean, data localization is the larger hot button issue, right? And so that for companies that are going to come within the ambit of the data localization provisions, there might be more significant kind of implications. And that might include setting up entirely new centers to kind of really redrawing how the data flows within their organization. It's going to be largely impactful. That said, I think that it is for the better, because as we kind of touched upon in one of our earlier questions, this is the legislation that's going to set India's treatment of privacy as a right, the way it's enforced, and the way that data is treated in India, personal data is treated in India, especially for the next 10-20 years at least, if not more. And so it's only fair that it should be one that provides a lot of protection for data subjects as well.
Yes, ma'am, that is true. Ma'am, the police are still enforcing Section 66A of the IT Act 2000, even after it has been repealed. So now in these instances, is it will it be more about implementation or, for drastic law, or is it more about just, the fact that they're not going to be those many changes, even if something has been repealed?
Well, no, I don't think that this situation is going to be similar to the Section 66A situation for 2-3 reasons. Now, the first one is that this is not an instance of an existing section or a clause whose the exact manner of the enforcement of which is really being debated over multiple judicial precedents, which is like a quagmire in itself. And then, finally you have 66A, which I think Shreya Singhal it was, that kind of really watered it down and kind of changed the way intermediary liability was looked at in India. And so it's understandable that, you have the absolute kind of first line of enforcement, that some amount is lost in communication there. Now, this is not a similar situation, because you have a large and sweeping act, which has been under discussion, the issue of a large amount of debate for many, or at least 3, 4, 5 years now. So there is a good amount of understanding that this is a completely new area of law, and that it's kind of being unveiled, so to say, for the data subjects and data fiduciaries in India. So I think from a priming perspective, your authorities are well primed to learn and understand that there are going to be a whole new set of compliances, areas of enforcement, etc. And I mean, if I think a more reasonable parallel would be something like competition or antitrust law around, and the MRTP Act being repealed and the Competition Act coming in around 20 years or so ago, and the kind of sweeping change that was. So I think this is going to be similar to that, if and not so much to some of the earlier sections that you mentioned. The second reason I think that and that one I think is an interesting one, is training and upskilling. And that's going to be very important. I think that's going to be the single most important determinant of how we are going to enforce this act. Inherently, the use of data, the way it flows, how we collect it, how we process it, how we transfer it, how systems are set up entirely, are enormously complex now. It is something that professionals in companies spend years trying to understand. And so I think enforcement of regulations that deal with the treatment of personal data are something that require some amount of training and understanding across different levels of the authority. And that's going to be extremely important. And I think training actually, I mean, as much as you talk about authority, is going to start becoming very important in within companies and data fiduciaries itself. And so you're really going to, what you would want is a three-pronged approach where you have, great amount of training within the authority to start understanding how do you enforce some of the regulations that are going to come out. So to give you an example, how do you know whether a certain method of collecting consent satisfies our regulations or doesn't, right? And what are the different acceptable modes? What do you mean by informed consent? And so all of these things are going to start becoming important. Concurrently, of course, once we have a clear and complete picture of what are all the compliances that are going to be required, the data fiduciaries are going to have to train and upskill within their systems. And a lot of the larger companies have already started doing that basis the earlier drafts that have come in, because of course we understand that there are going to be sweeping changes, and so everyone wants to be prepared for them. And then of course your last prong is going to be the data subjects themselves. So you're going to have to run a massive amount of awareness, since India is not a country, and in fact, to be honest, most data subjects across the world are not familiar with the nitty-gritties of what rights they have and what rights they don't. And when you're introducing privacy as a concept, it is a new concept even for the data subject. And so to explain rights, such as, to give you an example, the right of data portability. Now that's not a right your average citizen is going to intuitively understand, and it's going to have to be explained that your data is owned by you, and so it is your choice how to port it across different companies, etc. Now that's a concept that's really going to have to be fleshed out, and so I think effective enforcement is really going to rest on all of these three prongs.
Yes, ma'am, because unless and until people are aware, there is absolutely no way that we can discuss privacy. Ma'am, several new privacy regulations recommend adoption of privacy by design principles by entities collecting or processing personal data. Ma'am, what does privacy by design mean?
So I think this is I think this is one of the lesser discussed but most important aspects of privacy law. Privacy by design really starts as a concept in the 1970s, 80s. And the idea is really that privacy is not an afterthought. Now, when you design certain systems, do you take privacy into account at every stage, or do you give it an afterthought and try to kind of just make sure that your compliances are checked? In an increasingly complex world, as kind of I had touched upon earlier, if you are not designing to protect privacy, it's going to be harder and harder to, kind of authentically provide that right to people. Now, what that means is that privacy is going to be one of those unique, areas of law, which is not really going to just be understood and enforced by lawyers, but it's actually going to extend to engineers, to policymakers, and to business persons, because this is about designing processes that protect people's personal information. How does that play out in real life? So, for example, data retention is and kind of collecting minimal data are certain kind of guidelines that are given. It's there in the EU. It's going to come in with our act as well. And the idea is that don't collect data that you don't need. Don't retain data unless it's longer than necessary. But if I have not designed for it, then I'm not likely to actually be able to live out those principles. So when I am, for example, setting up a new program, maybe when you're setting up your bank account, or you're setting up a new account for any service, actually, has the service provider at that point in time, when they are designing their entire data flow, thought about what information they need and asked you only for that? Or have they said, let me just collect as much or as many data points as I can, and then kind of work from there? Another example could be maybe, if you're a student, you've interned with an organization 4 years ago, and they store a certain amount of your data, and you didn't end up, working with them again. And now it's been 4 years, but maybe on a set of servers somewhere, all of that data is still being kept. And it's because nobody has at that point in time, put in data retention as a design into their systems. Once these acts come in, ideally we also create a privacy culture where we start designing our systems and processes to protect privacy. And so, we start keeping those principles in mind. And it again comes back really to a large amount of training. And again, like I have been part of, conducting some of these trainings, not just for lawyers, but, for IT professionals, for our business managers, for people who head entire applications, because privacy is now becoming really a team sport, and not something that your lawyer is going to give you a checklist of compliances and, you can get that done. So it's really going to be a more concerted effort. And of course, you have companies like Apple, etc., which are almost on the front foot in the sense, if you've seen Apple's marketing now, which is actively, kind of making privacy an asset and saying that we design our entire phone and our systems to protect your privacy. And so that's kind of becoming a business advantage. And that's kind of the other end of the spectrum that you see. I would say in India, we're still earlier along that journey. But if you want to get an understanding of how privacy by design can really change a business, that could be an example to look at.
Ma'am, as for, speaking of businesses, how should responsible companies develop and drive this, privacy culture within their organizations? What's the step forward?
So I think that this is a very pertinent question. It's an extremely important question because we kind of stand on the precipice of this new sweeping legislation that's going to come in. Now, I think that privacy really is a culture. So, of course, you need to have, your lawyers, your legal counsels, and kind of your related functional professionals who really understand the new legislation coming in, spell out what the implications are, for their businesses, and, start that process of rewiring that organization to make sure that it's compliant with privacy norms. And that's why you do have a window of around 24 months that's given, because and to be honest, it's a reasonable window, because having, again, worked as an in-house counsel, there are companies that really want to comply in the most bona fide of senses, will require that time to really change their process and make sure that they have a very robust privacy culture. But the second part of it, really, from moving from just kind of compliance and advisory, is building that culture of privacy. And what that means is that, very much like, other things that have been driven culturally, other kind of legal compliance that have been driven culturally. To give you an example, some of the more legal ethics cultures, or say, creating an anti-sexual harassment initiative, and that it has taken companies, almost decades sometimes to really build a culture that's very consensus around some of these topics. Privacy is going to have to start straddling both. So of course, it's a law, it has certain very clear compliance requirements, but it's also a culture. And what I mean by that is, when you download a data set and you suddenly have a data, I believe the term is a data dump, and you have a data dump of a large amount of personal information that you absolutely don't require. Are you really deleting it from your laptop and saying, I don't require this, please don't share it with me? Or for example, if your colleague is asking you for some amount of data, which really can be anonymized, are you really sharing it in that form, or are you just, again, sharing the link to that data dump and saying, do with it what you will? Because essentially, or some of the more dangerous practices I understand are really sharing these large amount of data sets with enormous amounts of sensitive personal data on WhatsApp groups at work, because that's faster. So now these are things that no legislation can really kind of write in such fine print, because our culture is changing, technology is changing so much faster than that. So it is not possible for regulators to really sit and write such fine print, and that really can't be their burden. And so this is going to be a law which is, to some extent, has to be responsibly interpreted by authorities and by data fiduciaries and companies, and implemented as such as a culture. And so and that's kind of where, what I was saying a little bit about, large amount of training, some amount of awareness has to come in from companies. And so it has to be something that is consistently talked about. It has to be something that's spelled out and really broken down by our lawyers, because really telling someone, make sure that you protect the right to data portability, or make sure that you create informed consent forms, isn't really going to suffice. And so you're really going to need that kind of brainstorming and having an overview of how you can code privacy into every step where it's relevant in your organization.
Ma'am, as for, the RBI guidelines, which were dealing with data localization, that led to, multiple businesses, closing their, business ventures in India, stating the financial implications. Ma'am, do you think that a similar kind of possibility can occur with the personal data protection bill coming about and, pose a similar threat to foreign companies? Will it force them to withdraw? Also, if we were to claim that we need indigenous apps and companies, would it be practical in the global scenario that we cut ourselves off from the rest of the world?
I think these are very strong statements. I don't think that that's how the privacy regulation is going to play out. I would say that it is a necessity at this point for a country that is as significant, that's growing as significantly as India, to have a very comprehensive data protection legislation, and in general to have a data regime. And so the report talks about this as well. That if we're going to look at a data driven economy, and so much of our businesses are going to start growing that way, the amount of information that's being collected, it's an absolute requirement for us to start having a very robust legislative framework around it. I don't think that it actively discourages companies, or it puts off any foreign based organizations, and it shouldn't, because ideally what's happening is, as an economy and as a country is maturing in certain industries, it's starting to regulate as well. And that is expected, and especially when it comes to privacy, it's extremely expected, because India is not the only country that is bringing in a robust legislative framework. There are multiple countries across the world in the last 10 years which have brought in new regulations. GDPR itself was refreshed in a sense a few years ago, and kind of overhauled. So I don't think that the sudden rise in privacy regulation just in India is going to raise flag. Now, when it comes to certain hot button issues, so you could say localization, or the kind of responsibility that intermediary liabilities are going to start, that intermediaries are going to start holding, I think there was some amount of difference of opinion and space for debate. I understand that there were public comments sought, and there was an exchange from multiple industry bodies as well, where certain representations were made, and so you kind of see that dialogue going through as it should in a democracy, and so when you have a new act that comes in, I think it's impossible to please everyone. So it's going to, of course, it's going to bring in some amount of compliances, and of course that's going to increase costs. If that means that certain companies are strategically going to have to alter the way that they are going to project their business in India, for example, for the next 5 years, that's more of that's kind of a concurrent effect, but that really can't be an argument to the act not coming in.
Yes, ma'am, understood. Ma'am, USA grants citizens, right to privacy as a fundamental right. but they have been lagging in providing the same in the use of mass surveillance systems, etc. Ma'am, are these systems necessary? And what is the acceptable way to, use them and implement them?
Again, I think these are very sweeping statements. I don't think that there is no right granted to citizens against mass surveillance. These are actually parts of the law that are being discussed. They're being debated. They're being interpreted. As times change differently as well. There is always going to be, in a sense, kind of a balancing act between certain rights of citizens, as well as certain privileges that the state has. Let's put it that way. Firstly, I think most of the rights that we have are never blanket rights. So every right, so let's take the freedom of speech, right, comes with a reasonable restriction, because the idea is that you, as much as you can, you want to empower the citizen, you want to give them certain inherited rights. Privacy is now one of them in our country, for example. But when you're looking at kind of enforcing it, giving life to those rights, etc., there are sometimes reasonable restrictions that come into play, and so you'd see that in our constitution for freedom of speech, for example. The second aspect is duties of a state. And I mean, I look at it, I kind of draw it really back to the social contract, right? So in a sense, we allow and give up some portions of our completely free and vast rights to the state, because in return we get certain protections from the state, certain services from the state, and I think that this is a debate that kind of fits somewhere into that question, because you give, your state is then also tasked with providing some amount of national security, it's tasked with providing some amount of services to the citizens, and where that those kind of blanket rights and the privileges of the state, where they collide, and how that line is to be determined is a question for the ages, and it's always been debated in that sense. In India, again, when it comes to privacy, the question has come up because the state in the newer act has some amount of larger privileges. It has a large amount of exceptions as well, and there are certain non-obstante clauses which have come in, which exempt the state. And again, like, I think that this is one of those instances where it really depends on once the act is really in force, how are the different stakeholders going to really utilize the rights and privileges that they've been provided. And so a little bit is going to really depend on the act in practice itself. That's kind of where I'd make it. But I don't think that either of the statements that kind of start to make, these are questions that are very intertwined, not just legally, but then also with some of the larger social and cultural issues of the day.
Ma'am, a recent study has shown that nearly 98% of the users have agreed to the terms and conditions of an e-agreement without even reading them. Now, the terms of that particular agreement that individuals signed held clauses, wherein the platform had the right to receive the firstborn of the user as payment, and that their data would further get transferred to the NSA. Now, ma'am, do you think that this haste of people to just agree to the terms and conditions, and this happens every day, no matter whether we're buying some products, we're just entering some site, we always accept the set of terms and conditions. Do you think that this would, lead to, contributing factor to cyber crimes? And how can, the upcoming privacy data protection laws focus on this aspect of it?
So, I mean, to some extent, they already do. The phenomena that you're referring to is called consent fatigue. And you're right, it's a almost daily occurrence now with most of us who, are plugged in online. What essentially it means is that, consent norms are, they are often so complex. Alternatively, companies put out such complex terms and conditions of use that as a user, you just click okay, and move on, because that becomes the barrier to the service that you require. And what that's called is, it's called consent fatigue, because as a user, you are so fatigued of consenting to different things that you have now stopped, actually processing and understanding what that consent notice is telling you. And in fact, in a large amount of interpretations, such kind of consent fatigue then nullifies informed consent, because it really does not meet the bar of what informed consent is. Now, there are two ways in which I think, this can be countered. And you'll see a large amount of responsible organizations already proactively, try and remedy that. So the first one is, there are newer norms and kind of best practices on how to frame a consent notice. And one, the newer understanding, and especially coming in from the GDPR and the way it's kind of being practiced, but in general as a best practice, the understanding is that when you provide a consent notice, it has to be simple. It has to be in a language that the person understands. And if you're looking at a best practice, not just, kind of say English or French or Hindi, but it has to be in kind of removed from some amount of legalese. So it has to be very simple, and it has to clearly inform, and take consent for certain aspects of use of data, right? And you'll kind of start seeing that in certain, on certain websites, etc., because now OneTrust, to give you an example, has now started creating base templates again, on really simple, on a very simple interaction on consent, right? Because ideally, what I need to tell you is that, why am I taking your data? How am I going to use your data? Am I going to share it or not? Take your permission on a set of things dependent on which jurisdiction I am and what laws apply to me. So those are that's the basic communication that has to come in. Now, the answer cannot be, let's do away with consent notices, because we want to protect your right to consent to the way your data is used. The other way, so the first part is, of course, drafting consent notices and making that experience one where fatigue is reduced. And the second part, of course, is legitimate expectations. And I think I have a slightly different opinion. I don't think that as much as legitimate expectation can sometimes be used, to kind of not ask for explicit consent for some of the smaller uses of data. I think it's actually, if used well, it can reduce the burden on us to constantly consent, and the consent fatigue that it brings in. Because what legitimate expectations means is that I don't need to ask for your consent once you've shared your data with me, if my use of data falls within certain definitions of what legitimate expectations means. And then, of course, those definitions are provided by law. But a very simple example of that would be, if I'm your employer and you've provided me your information, and I have used that to set you up with some amount of, say, healthcare internally. And we're just going through a reboot of the same, and we're probably moving it to a different server. I don't need to ask for your permission. Can I move it to another server, for example? Or I can just make that a seamless experience for you, because it's legitimate expectations for me to use data that you've already provided and consented to, to continue providing you that service as an employer. And so it reduces the amount of, say, I don't want to use the word frivolous, but say repetitive or fatigue-inducing consents that you have to sign. So I think that's a second softer way of countering it.
Ma'am, for my last question today, I would just like to know, ma'am, what are some recommended sources, for lawyers who are interested in learning more about privacy, since it's a fairly new subject. So, under the situation that lawyers and law students
Absolutely,
want to learn about privacy. So how would they, what are the recommended resources for the same?
No, I absolutely I agree with you. It's an enormously exciting space. It's developing extremely fast as well. So and different countries have new laws coming in, different laws coming in. So lots to learn. Some of the sources that I regularly follow is the International Association of Privacy Professionals, so that's IAPP, and their blog. I think they're one of the best kind of updates and learning more about privacy law, not just in India but also across the world. The websites of, for example, the EU and GDPR's official websites, I think are again great places to go, because I think they kind of really break down a lot of the information and regulation that's present. I think another place where people can really start exploring privacy law is also just kind of go through some of the seminal works in India that we've had, and I think they're very instructive themselves. So to give you an example, just read the Puttaswamy judgment, the Sri Krishna, the Sri Krishna committee report, and then the most recent JPC report. And the reason I say that is because in themselves, they're extremely comprehensive. They provide an overview of how privacy law has grown in India. They provide a comparative assessment of the laws in India right now, as well as the ones in EU, in the US, etc. And so I think if you're somebody who's kind of never really dealt with privacy law before, these are definitely first places that you should go to. The last code, it's by Lawrence Lessig. And if you again are at all interested in law and technology as a space, I think it's a fabulous book to read, and it really kind of talks about something I believe in very much, which is, as lawyers who are interested in technology, you really have to go that extra mile, not just to engage with the law, but to engage with technology, and to look at, law as a code for, for our future, and for an increasingly technology driven future. And so I think it's an enormous book to start with.
Yes, ma'am. This brings us to the end of this podcast session. It has been really great having you here. I would like to thank you for answering all our questions, because this would be really helpful to, people within the country for the awareness purposes, because privacy is fairly new, like we have said. And thank you so much, ma'am, for coming. I would like to thank you on behalf of the entire team of TLJT for making it here today. Thank you so much, ma'am.
You're very welcome. It was my pleasure talking to you.